with recitation of Al-Fatihah. Okay, so for our class this morning, so we are going to discuss about the entry of appearance. Kita akan go through cases by cases lah, how the judge evaluate that, how the court assess that appearance in terms of late of appearance. So macam mana dia punya procedure dia, and what is the proper way for the defendant to do, the plaintiff to do, and etc. So kita start dengan sesiapa nak volunteer ke? Semua dengar ke?
Dengar.
Ada sesiapa nak volunteer ke?
Tak ada, proceed. Cuba display question.
Display question Okay, so sekejap Alright. So this semua nampak Okay, so sekarang ni kita akan go through case soalan nombor 3 terus Discuss this case law on the topic of appearance to read. So our first case kita dengar daripada case Tan Leong Hong and Mingai Knitting Factory. Any representative from KLB1? Mungkin daripada TLB1 ke? TLB1 dan TLB2? Hello? Hello? Ada sesiapa ke? Dengar ke tak dengar ni?
Ada, cuma tak, dia macam kadang-kadang suara you macam putus tadi. Tak tahulah kalau tempat yang connection tak bagus, maybe tak tahu dia putus kot dengan suara you.
I see. Tapi doktor dengar ke?
I dengar.
Kita start dengan my case teruslah.
What's your case?
My case, sekejap saya buat. Right, so this is our firm's case, Asfa Associates. Kami buat case 1 Muhammad Sofyan bin 1 Mat Saad and MBF Finance Berhad. Doktor dengar ke?
Dengar.
Semua orang dengar?
Dengar. Suara you putus lah, I tak tahu line you teruk ke line I yang teruk ke, korang okey je?
Dengar putus.
Syami, suara you putus. Tak stable. Line tak stable you punya line.
To enter dia. Macam mana tu? Daripada Asfa Associate, ada siapa ke nak present?
Okay, kita dah Assalamualaikum warahmatullahi wabarakatuh. Okay, there are 3 issues that can be highlighted in this case. Dengar tak?
Tak.
Dengar.
Dengar.
Dengar tak?
Dengar.
Dengar sangat.
Dengar.
Okay, for this case, there are 3 issues that can be highlighted. Firstly, the issue is whether the defendant can find. Ya. Aku tengah baca ni. Okay, first issue is whether the defendant can file the memorandum of appearance even after the time permitted has passed. Secondly, whether the plaintiff entitled to enter interlocutory judgment against the defendant for the damages to be assessed after the defendant has passed the time limited for appearing. And last issue is whether the failure of the plaintiff solicitor to serve the defendant a notice indicating his intention to enter judgment by default, contrary to Rule 56 of the Legal Profession Practice and Ethic Rules 1978. So, moving on to the fact of the case. Okay, in this case, the defendant has made an appeal against decision made by the learned senior assistant registrar, which allowed the plaintiff claim to set aside the memorandum of appearance and give the plaintiff liberty to enter judgment for the sum of 1 million as general damage on the ground that the defendant has failed to file the memorandum of appearance within the time permitted. In this case, the last day for filing appearance was on 18 February 1999, but the defendant only entered appearance on 19 February 1999, which was a day late. But he had served a copy of the memorandum of appearance to the plaintiff on 18 February. So, sambung.
Okay, next, for the provisions involved in this case is in the order 12 rule 4. Clear ke?
Clear. Dengar.
So yeah, clear.
No?
Suara you yang putus ke I yang tak dengar?
Under this order, we can divide into two. That if
Dengar ke macam ni?
if the writ itself within the jurisdiction, either within Peninsular Malaysia or within Sabah and Sarawak, the time limited for the appearance to be made is for 18 days. However, if the notice of writ is served out outside of the jurisdiction, the time limit for the appearance is 21 days. So there are two time limited under this order, and then under this case, the defendant had lead for 8 days, and then for under order 12 rule 5, the consequences if there is late of appearance, defendant may not enter an appearance in the court if there is judgment had been made. If the judgment had been made, however, except as provided in paragraph 1, if the court given permission or leave, there is leave from the court, then the defendant may do so, even they are late for appearance. Okay, that's all.
Okay, now coming into the last part, and that is about judgment. Okay, just as what Fatin Hanis had mentioned just now about the issue. The issue is, I mean, the plaintiff is arguing whether the defendant can enter appearance even though though the time limit has passed. So the judge had held that the defendant is only precluded to enter appearance only if the judgment has been entered, unless the defendant obtained the leave from the court. But then in our case right now, the judgment has not been entered yet. So the court said it is okay for the defendant to enter appearance even though it is 1 day late. So it's not precluded to enter appearance. Hello?
Ha.
So,
Ha,
Habis dah
dengar
ke?
tu. Ha.
tu dah ke?
Okay. Kejap suara you on, kejap suara off. I tak tahulah line I ke line you all lah. So basically dengar tak?
Ha, putus-putus juga.
Oh ya. Yeah. You duduk mana Syami?
Saya duduk dekat rumah.
Yolah, rumah hang kat mana?
Oh, Johor.
Johor? Johor kat mana?
Johor Bahru.
Oh, Johor Baru, Bandar Bosah. Banyak kot
Ha.
pengguna. Banyak pengguna kot.
Ha.
Okay. So basically ada 3 principles lah tadi ya from your case.
Yes.
So basically
That's nice.
kalau after 7 days apa dia kata after the time limitation for appearance still boleh apply to the court to appear. Is it?
Yes.
Before judgment.
Okay.
Yes.
Tapi do we need the court punya leave or not?
Before the judgment entered, you do
After
need. After the judgment entered, then you need leave from the court.
You need leave after judgment entered, you need leave from the court. But how about before the judgment entered?
The defendant can enter the appearance, but then he cannot expect that the appearance is as if it is seolah-olah macam dia punya appearance tu the normal one. So kena ada dia punya etika dia lah, macam as we learn yesterday, we have it is appropriate for us to ask for permission, right?
Yeah. And then yang Sabah Sarawak tu dia patutnya 14 days kan? Kenapa dia jadi 21 days? Why?
Yang mana?
Yang second principle tu tadi. You cakap
Oh, Alia.
Alia. Ha.
Alia?
Sabah dan Sarawak kata 14 days kan?
Yang dia lama punya rule of high court,
within
1980.
Putus. Apa tadi Alia cakap dia putus. So basically order lama kata 21 days boleh Order baru kata
for
kena
the
14
second
days.
principle, 14 days. Yes,
14
madam.
days. So order lama yang 21 days.
Yes.
That's not fair.
Yes.
Okay. So how about the third principle yang you cakap tadi?
For the third principle under Order 12, Rule 4 ke, madam? Okay, for the third principle, if the notice, if the writ was served
Putui.
11 Rule 4, putus.
Okay. Dengar balik. Okay. Lepas tu continue.
Okay, if the writ was served outside of the jurisdiction under Order 11 Rule 4, it must the appearance, the time limited for the appearance is 21 days after the serve.
So 21 days tu for out of jurisdiction macam I cakap semalam lah.
Yeah.
Okay. So so basically when you answer appearance punya questions, these are the cases yang you kena masuk lah. Apa nama case tadi?
Wan Muhammad Sofian.
Tan Hong Leong.
Against
Wan Muhammad Sofian penting case ni. So you know
Wan Muhammad Sofian.
Wan Muhammad Sofian.
Dr. Wan Muhammad Sofia yang teliti.
Okay. So basically, cuba share you punya you punya case briefing tu dekat documents. So Wan Muhammad Sofia dia punya principles dia 3 tu tadi. So boleh ingat tak? Ada 7 cases tu dia. Nanti kita recap lah before kita.
Ya, Doktor.
Alright. Share you
Yes.
punya
Wan Muhammad
document.
Sofian.
So share you punya document. So next, Syami.
Boleh. Alright, so the next case will be a case of Kong Yik Beng. Kong Yik Beng ada? Any representative? Hello? Any representative for the case of Kong Yik Beng?
Dia siapa punya group tu? Kongi Bank.
Kong Yik Beng grup Rahali ke?
Guru siapa?
Grup sekejap.
Azman. Yang mengilai tu.
Hello? Maybe daripada KLB 2 ke? Ada ke?
KLB 2. KLB 2 siapa? Ashraf ke? Kan? Guru Ashraf kan?
Eliana Fatin ke? Ashraf?
Ashraf dia duduk diam je tu. Tadi pergi makan ketupat kot Ashraf. Dia tertidur.
Oh, tak apa. Maybe from Eliana Fatin.
Saya wujud madam. Cuma saya tak menelaah lagi yang tu.
Alah, tak menelaah. Kau memang tak apa kau buat. Kau buat lemang ke?
Saya anyam ketupat semalam madam.
Sudahlah yang ketupat macam kau reti. Apa tu ni? Dia punya ni ada tak apa dia punya summary ada tak? Kalau ada letak je situ suruh si Syami baca. Share screen. Kau online tak boleh share screen lah.
Boleh je.
Okey. Siapa Sogan nak baca tak tunjuk muka pun Sogan. Nampak tu? Cik Atira.
Atira Renan.
Atira.
Atira Renan, yes. Boleh.
Speaker dia tu tak on. Lukman dia kata. Nazira kata Lukman.
Lokman.
Lukman dah ready kot.
For case Kong Yik Beng.
Apa reply jawablah. Dia tak ada ni. Lukman.
Mai masuk mai.
Assalamualaikum.
Mai.
Salam.
Salam.
Petik nama orang. Kejap
Apa tak ada?
Clear tak?
Clear mai. Answer mai.
Macam mana nak share screen?
Tekan button yang ni man. Sebelah button yang titik 3 tu ada bahagian share tu man.
Dapat?
Okey, nampak man.
Okay.
Wah.
Dia macam ni. Masa 15 Disember 1999, si appellant tu, si Kwong Yi Bank ni, dia nak ubah tarikh, tempat dan masa untuk dia appeal kes sebelum ni. Sebelum ni kes dia kalah. Jadinya dia punya next proceeding adalah pada tarikh 9 Februari 2000. Dia filekan appeal ni on behalf of body corporate. Maksudnya sini dia tak ada legal representative langsung. Dia sendiri yang wakilkan untuk appellant. So kalau ikut rules dekat Rules of Court 2012, kalau kita refer pada Order 12, Rule 2, dekat sini dia bagi tahu a defendant to an action which is a body corporate may not enter an appearance in the action or defend the action otherwise done by a solicitor. Maksudnya dekat sini, kalau dia body corporate, dia kena through solicitor juga, legal representative. Jadinya court terpaksa dismiss appeal. Faham ke?
Faham.
Faham.
Sebabkan dia represent diri dia sendiri Tu tak boleh tu kan.
Simple je kes ni.
Okey.
So itu je pasal pasal dia punya apa nama tu representative je sebab dia punya
betul.
appearance. Apa saya tak pakai lawyer?
Maybe saya rasa dekat body corporate ni ada bahagian legal juga tapi dia bukan solicitor.
I see.
Okay.
Saya tak tahulah dalam body corporate tu macam mana dia punya hierarki.
Kayaknya itulah silap dia. I see.
So
Okay, simple.
basically dia nak buat amendments to dia punya memorandum of appearance
Yes.
So dia nak masukkan solicitor ke dia nak represent diri dia?
Dia nak represent diri dia tapi dia tak through legal action by solicitor. Dia through as a body corporate.
That's why the court dismiss.
Yes.
Okay. Alright. Senang kan? Kwong Yi macam tu kes dia. Kita boleh ingat lah nak exam. Nak exam tengok muka Luqman dia ingat dia cakap pasal Kwong Yi Bank dia nak represent diri dia sendiri.
Yeah, betul. Okay, next case. Thank you.
Betul. Okay. Right. Can we have next case from case of Bintulu? Thank you, Wen. Next, can we have the case from Bintulu?
Yes.
Okay. Wawa. All right.
Right. So basically my group, which is can you hear me?
Yes, Akila.
All right. So basically my group, Wang Abdullah, proceed to the case of Bintulu Adhesive and Chemicals Nyamerhat and Chua Seh Jo Bollywood Industry Sarawak Sdn Bhd. Okay. So basically, we have divided this case into two main issue, which the first one is the first issue whether a defendant is required to serve a copy of MOA is Memorandum of Appearance to the plaintiff within a stipulated time limit. Alright. In this case, actually on 30 November 1999, the plaintiff has commenced an issue or action against the defendant. So they have some issue. So plaintiff have commenced an action against the defendant, and the plaintiff had issued a writ. But then, as we know, the writ must be come together with a statement of claim. But this plaintiff does not issue a writ together with a statement of claim, but it was instead endorsed with a concise statement of the nature of the claim made. Means that the plaintiff tak bagi sekali dengan statement of claim, cuma dia nyatakan apa yang dia nak claim dalam dia punya proceeding, just nyatakan secara macam tu je, tapi dia tak bagi secara formal the statement of claim tu. Okay, and then on 22nd December, the writ was served to the defendant, and and then it stated that 10 days later, supposedly the defendant had give their memorandum of appearance. Okay, but the defendant already supplied the memorandum of appearance to the registrar of the High Court in Cebu. But the defendant does not give the copy of the memorandum of appearance to the plaintiff. And plaintiff said that, when the defendant tak bagi dia punya memorandum of appearance kepada plaintiff, so sebenarnya defendant ni dah melakukan satu kesalahan lah sewaktu proceeding tu. Macam tu. Jelas tak?
Jelas.
Okay, so actually sebenarnya defendant tu dah bagi memorandum of appearance kepada registrar of the High Court Registry Cebu, tapi dia just tak bagi kepada plaintiff, and plaintiff claim benda tu salah according to the rules of High Court 1980s. Okay, but then the court decide on the first issue, actually the defendant had not commit any irregularities in regards to the serving memorandum of appearance, because there is no requirement to serve a copy of memorandum of appearance to the plaintiff. Only defendant need to require to serve the memorandum of appearance to the High Court Registry Cebu only. So mean that kepada plaintiff dia tak perlu bagi pun sebenarnya, just perlu bagi kepada High Court Registry of Cebu saja. So dekat kes ni defendant sebenarnya tak melakukan apa-apa irregularities pun. Okay, so sebenarnya dia dah buat benda tu within stipulated time. Okay, that's for the first issue. And the second issue we proceed to with my other member of group. Thank you.
Okay, Assalamualaikum warahmatullahi wabarakatuh. So we proceed to the second issue for this case. Thank you, Shami, for sharing the slide.
No, it's Amira.
Oh, Mira. Okay, thank you, Mira.
Ah.
Okay, so for the second issue, okay, whether the plaintiff can set aside defendant's appearance when there was no writ of summons issued by them in the first place. Okay, so basically, in this case, the plaintiff wanted to summon the defendant, but they didn't serve the writ of summons to the defendant. So, if in the first place diorang tak serve writ of summons tu, so how can the defendant proceed with the memorandum of appearance, because the writ of summons is the first step to summon a person. So the plaintiff, without serving a statement of claim to the defendant, entered a judgment in default of defense, because by referring to the first issue, they claim that the defendant had late in presenting their memorandum of appearance. So they wanted to enter a judgment in default. But how can they enter into a judgment in default if the plaintiff themselves in the first place tak serve statement of claim pun dekat defendant? Faham tak?
Okay. Faham.
Okay.
Got it.
Okay. So for the second issue, judgment, kita refer Order 18, Rule 1 of the Rules of High Court, which stated that unless the court gives leave to the contrary or a statement of claim is endorsed on the writ, the plaintiff shall serve a statement of claim on the defendant, or if there are two or more defendants, on each defendant, blah, 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 blah. So, Order 18 ni requires a plaintiff to serve a statement of claim, on a defendant unless excused from so doing by the court or the statement of claim is already endorsed on the writ. Mira, boleh move to last slide. Hello.
Dia buffer sikit
Okay. Okay, thank you, Mira. Last slide. Okay, so conclusionnya, the plaintiff tak entitled pun untuk ask judgment in default sebab plaintiff sendiri tak serve writ of summon dekat defendant in the first place. So, it would deprive the defendant of a substantive right afforded to it by the rules to be served with a statement of the plaintiff's claim and to file a defense thereto. So conclusionnya kat sini, plaintiff sendiri first place tak serve writ, so dia tak ada hak lah nak ask for a judgment in default for the defendant. Okay, that's all.
Oh, so basically judgment in default dia kena dismiss lah. The idea dia.
Yep.
Pelik kan? When you all present all these cases, you rasa pelik tak? Kita despite all the rules that we learn kan, kita rules dia kena ada serve statement of claim, that's a requirement, procedural requirement kan?
Yes.
Lepas tu still dia tak file and
tak
then
buat.
lepas tu dia terus JID kan, that's irregularity lah kan? Obvious irregularity in proceedings. Lagi satu yang first tadi, dia tak buat apa tadi? Dia tak
serve
dia tak serve memorandum of appearance to the plaintiff tapi benda tu rupanya bila I check balik according to the rules, dia bukannya kena serve to the plaintiff, dia kena file it to the registrar.
Yes, madam.
Yes.
Betul.
So basically bila kita buat cases ni, kita nampak variety of what things can go wrong in our real practice.
Okay.
So basically boleh jadi macam problem question kan? So kita macam kita buat macam complicate sikit, letak sana letak sini bagi you all fikir. Tapi selalunya kalau open book test will be that kind of questions lah. Dia tak straightforward dalam buku you all punya rules of court tu, you all kena fikir lah dia. So dia mostly daripada case briefing punya case.
So ni hint lah doktor
Hint lah. Dah lah recorded. Okay, good discussion. Apa nama case tadi? Bintulu
Bintulu.
Okay. Good. So far there are 3 cases. So you boleh recall tak? You boleh bayangkan tak? There are 3 cases that we discussed ni. So hopefully it will help you lah kalau nak put those cases in your essay or problem question.
Betul.
Right. Move on, Syami.
Alright. Can we have the last case? Can we have the case of Kenichi maybe from KLB2? Any representative from KLB2 to brief about the case of Kenichi? 1 Aunia Akila ada ke? Any representative from KLB2? Hello? Semua dengar ke?
Jangan. Tante dia pergi buat air kopi kot.
Case maybe case Tan Yang Hong. Kalau tak ada Kenichi, can we have the case of Tan Yang Hong for the last case?
Assalamualaikum.
Waalaikumsalam.
Sihat ke semua?
Alhamdulillah sihat. Syauki sihat ke?
Sihat. So guys, saya tak ada return saya tak sempat nak buat written, tapi saya boleh cerita briefly regarding on the case. The case of Tan Liang Hong against Min Ngai Knitting Factory 1974. Case ni regarding entry of appearance to WRIT. So brief fact regarding on the case is the plaintiff to seek remedy for the negligence that have been done by the second defendant, which is her co-worker in the company of the first defendant when there is some problem with the machine in the factory that caused the two fingers of the plaintiff to be cut off, if I'm not mistaken. Tercabutlah dia punya jari kena mesin tu. That allegedly caused by the
Okay.
second defendant. So when she decided to to call the second defendant and the first defendant to come to the court, it is only the solicitors. It was the solicitors that representing them to the court. But the issue is that whether or not the entry of appearance to it extend to the second defendant for the solicitor. And as we learn in the Rules of Court 2012, Rule 12, there are several mode of appearance to the court, and one of the appearance is by the solicitor to be the representative. But court held that the solicitors that was being insured by the company, maksud dia telah di-insured, di-insurance, kalau saya tak faham untuk kalau saya tak silap, untuk mewakili company itu tidak extend kepada second defendant, it only extend to the first defendant only. So the plaintiff have the right to question the perwakilan solicitor kepada second defendant. Meaning to say he can proceed to judgment in default lah sebab second defendant failed to appear to the court. That's all.
I see. Faham?
Second defendant tu bukan employee first defendant
Yes.
Kan dia solicitor.
Oh, dia bukan satu company ke apa? Kenapa dia tak boleh represented by the same solicitor? Lupa pula.
Sebab dia representative tu dia tak sampai ke pekerja tu, kalau saya tak silap lah.
Oh, just up to some level of employee je lah. Kalau level bawah tak represented.
Tambahan pula, sekiranya orang tu, which is second defendant, tak memberikan instruction kepada solicitor untuk minta dia diwakilkan, jadi representing kedudukan representing tu akan remain vacated. Ini by referring to the case of Gray against Coles.
Okay, tu. Okay. Betul. So basically, kalau representation in court, you know, jadi lawyer kepada any plaintiff or defendant, usually you appoint them, you do a written appointment secara bertulis tau. Kalau tak macam ni lah. You cakap aja nanti court may question the authority, so isu-isu macam gini lah. So dia jadi susah. So tu yang dia, sebab dia tak represented, so GID was entered against him kan? Ya, tak semalam I cakap kalau dia unrepresented ataupun dia represent themselves, GID can be represented against them kalau dia tak enter appearance. Tapi kalau dia ada lawyer, tak boleh senang enter appearance lah. Kena the plaintiff lawyer kena bagi 7 days advance notice.
Sebab dalam kes ni, second defendant tu berhenti kerja, diberhentikan kalau saya tak silap, dan cannot be traced. So macam mana kita tak minta diwakilkan, dia tak cakap apa-apa pun.
Betul-betul.
Dia pun tak jumpa. Macam tu lah.
Betul-betul. So those are the practical things, the technical things that will happen during civil litigation lah sebenarnya. Dia not as
Alright.
easy as in the rules of court punya buku. Dia a lot of complicated things happen. You see, so these are apa orang kata reality of practice lah.
Yeah.
Okay. Dah habis dah ke Syamil? Cases?
Case like almost it's already 9:50. Can we stop it because I'm the lecture after this?
You have other lecture after this?
Yes.
Okay. Alright. So, okay, 9:52. You memang on time After this, what lecture?
Civil and Criminal Sharia Procedure by Dr. Abida.
Oh, dengan Dr. Abida. So, Microsoft Teams juga?
Yes.
Alright.
Yeah.
So basically, you all upload you all punya notes dekat documents tu. And then,
Okay.
yang Syauqi tadi, you boleh buat mental notes anywhere tak? Notes dekat situ. And then upload dekat this group. Boleh? Syauqi?
Saya boleh buat lepas ni, saya upload kat situ.
Alright. So nanti I letak apa-apa yang I nak buat tu, I semua letak dekat sini lah. I nak buat attendance kat situ. And then ada apa-apa lagi nanti I put it in this group, okay? You all tengok.
Okay, boleh doktor.
Alright. So, nampak gelap dah. So, thank you all very much for your participation, especially our chairman today, Mr. Syahmi. So, itulah next sebab kita dah buat ni, nanti next I think kita nak buat simple ni lah. Simple mention for JID. Nanti I record. Sikit. Alright?
Okay.
Okay.
Alright.
Alright.
Okay, thank you doktor.
Okay.
Okay.
Thank you,
Thanks
Doctor.
Bye,
all.
everyone.
Assalamualaikum.
Thank you, Syami.
Bye, Assalamualaikum.
Assalamualaikum.
Thank you, Madam. Assalamualaikum.
Madam, Islami.
Salam. Ni macam mana I nak share recording ni?
Okay, Madam. Terima kasih.
Bukan I kena ni. I kena stop recording. Yes.